now in session.
Thank you. Please be seated. Good morning. We're here for oral arguments on Ahern Rentals, Inc. versus Equipment Share. It's our CV220661. As you know, we both live stream and record this argument, so when you approach the lectern, if you'd please let us know your name as well as the name of the client you're representing, that would be great. Each side has 20 minutes per side. You're in charge of keeping track of your own time. Please understand before you start that we have read your briefing, we have studied the record, and we've conferenced this case just prior to oral argument. And so with that, please proceed.
Thank you, Your Honor. Good morning, Judge Bailey, Judge Campbell, Judge Weisenweg. My name is Peter Prinkevich. Along with Connor Nolan of Littler Mendelson, we represent the appellant, Ahern Rentals. And, Your Honors, this case is about the misappropriation and misuse of Ahern's customer-specific confidential and trade secret information on behalf of a competitor, Equipment Share. The misuse and misappropriation happened both during and after Ms. Gutierrez's employment with Ahern. Before Ms. Gutierrez joined Ahern, she entered into a confidentiality agreement with the company protecting this customer-specific information. And I want to make clear what we're talking about, because we're not just talking about general information that's easily accessible to the public, like the names of potential customers. We're talking about specific information about customers that you only learn as a result of working with those customers at Ahern. For example, contact information for a specific purchaser, cell phone information. You might know that a company needs to rent equipment, but you don't know who to contact or how to contact them. You don't have a relationship with them. We're talking about purchasing history. What kinds of equipment does a...
Wait, she couldn't take along with her relationship with somebody?
The relationship, yes, but...
She can't take that with her. Well, you mentioned that as one of the things, was that you can't know who the contact person was, you can't have a relationship with them, but her relationship with prior clients is not at issue here, right?
No, but Your Honor, the relationship is something you build over time while you're at Ahern.
Right, but she takes that with her. She can't leave that at Ahern.
Well, you know who the person is.
Right.
And you have a relationship. That's not off limits. But the contact information for that person, the
address, so knowing who the person is that you deal with at a customer is not protected, but the address and the phone number are?
I think the address and the phone number in particular is something you learn through efforts. That you learn that by going to the job site, getting a list of subcontractors, pounding the pavement, putting in the work. And you learn that and this other information about the customer, such as the equipment needs, what do they use, what's their revenue, all that sort of stuff you learn while you're working for Ahern.
When we see this arise, typically we see this in a non-compete clause arena. This is actually the first time I've seen this alleged as a trade secret. So when we look at the definition of trade secret, is this a formula, a pattern, a compilation, a program, a device, a method, a technique, or a process? Where does it fall into the first definitional category?
Well, it falls in on information. It says trade secret is information, including a compilation and all those things you named, Judge Campbell. So it's information that derives independent economic value from...
So it's information including one of these. Which one of these are we talking about?
We're talking about compilation of information about customers, such as equipment needs and preferences.
Okay.
You said that the customers, the identity of the customer is not a trade secret, I think, earlier in your remarks, right?
Yeah, I think the identity of customers who may need to rent equipment is something that could be known.
Okay. So let's say, first of all, how big is that market? Heavy, frequently, I guess, are we talking about people who do it frequently, rent heavy equipment, or probably rent?
I think we're talking about people who do it frequently, but there could be new players who enter.
And how big is that market? I mean, and if you might not know that, and don't worry.
Yeah, I'm not sure how to quantify that.
Okay. So let's say then that the defendant here, Gutierrez, calls a customer that people know, and they say, we have this for sale, and here's the price, or what do you need? We know the customers, right? We just settled that. So what prevents her from picking up the phone and saying, how you doing? We know you do this. What do you need? And then you find out the unique needs.
Well, she would know, if it's a customer she dealt with,
Right.
she would know their needs because she dealt with them at Ahern. But nothing prevents her, aside from that.
Or anyone, for that matter.
Right. Anyone calling up a customer, once you get the contact information, calling up the customer, asking what you need. But what she can't do, Your Honors, is use her knowledge, whether it's in written form or memorized. And that's from this court's decision in Khaleesi versus United Financial Services. She can't use her knowledge of information such as pricing to undercut the Ahern's price on behalf of a
How
commissioner.
isn't that the essence of competition? Is she supposed to say, I forget the price that I was charging last week, but now I'm going to give you a better price? Or she can't beat their price? What are you saying? What are you arguing?
No, she can beat their price, but she can't. For example, we have evidence in the record where she's talking to customers and saying, here, before asking them, what do you need or what can I provide, I can provide you better prices than Ahern.
Okay, but so you're saying that if she'd gone through the exercise of, she has a customer, you have a client who has a specific buying agent and there's a specific price that Ahern has given them, and because you're saying that she took what you already had to answer those questions, if she would have called customer A and said, hi, customer A, can I talk to your purchasing agent, and talk to the purchasing agent because she got connected there, and then said to the purchasing agent, what do you need? And he says, I need a dozer. And she said, okay, well, what has Ahern or other companies been charging you for that dozer? And they tell her that would all be permissible and she'd be able to undercut prices that way, but because she may have had access to that information at Ahern, I don't understand how she acts in the marketplace, what the difference is between the head start that you're saying she had having that information when she could have readily gotten all of it from one phone call.
And isn't that in the statute? That readily ascertainable, so subsection A, it derives economic value from not being generally known to or not being readily ascertainable by proper means. So what Judge Bailey just asked, are those proper means, and is that readily ascertainable?
Yes, those are proper means, but it's not readily ascertainable. I mean, the whole thing, Ms. Gutierrez testified in her deposition about all you have to go through to get this kind of information, how you have to go to a job site, get the subcontractor list, go visit the subcontractor. Sometimes you don't get the list. Go visit the subcontractors. Ask for the contact information. Ask for who is responsible for purchasing, which is only successful 50% of the time. You have to keep working to try to get that information. And that is the kind of information that Khaleesi says is subject to trade secret protection because it's not readily ascertainable. It's not just a matter of making a phone call. There's no public directory, this is the purchasing agent. You've got to do the work. And Ms. Gutierrez, not only in her testimony, recognizing that in her deposition, at the end when she resigned, and she had information in her phone that was Ahern's information, she cleaned it. And the reason she said she cleaned it is because I didn't want Ahern to have the benefit of all my hard work putting that together. So that is not, Your Honor, readily ascertainable.
If we accept, again, going back to the first few sentences, the customers are known. And let's say you call the customer, you call the number, the jingle on the commercial or whatever, and you say, I sell heavy equipment, who's your purchasing agent? Is there anything in the record, which is what you need, anything in the record at summary judgment that said, they're going to be like, are you kidding me? We're not going to tell you that. Or we're not going to tell you that.
Yes, there's Christina Gutierrez's testimony that says she had to go through that process. She would go visit the subcontractor's office, ask the receptionist for this information that you're talking about, Your Honor. Give me the purchasing agent's information, and 50% of the time it would be unsuccessful. She'd have to keep going back. And so it's this kind of effort, when you're having to put effort in to develop this information, that's the kind of information that this court has recognized.
I mean, you're interpreting it as a non-compete. because what's in her mind and in her brain, she can't just wipe it. She knows who the contact, we already said, we know who the customers are. She knows who the contact agent is. What you are asking for is an application that would prevent her from competing, from what she knows in her head, which is Susan at Building Co. Inc.
We are not, Your Honor. We're not, you're right, she does not have a non-compete. She does not have a non-solicitation. She can resign from Ahern today and tomorrow, or even today, go work for Equipment Share, solicit customers. There's one thing she can't do, and that is use the information, the confidential information that she developed on Ahern's behalf to undercut.
Confidential information. Explain the nature of what you believe to be confidential.
Yes, Your Honor. That's the customer-specific information that I'm talking about. With Ahern, there are 816 pieces of equipment that Ms. Gutierrez was working with. She was working with 100 customers. There was individualized pricing. So she can know, because of her work at Ahern, what kind of equipment does customer X rent? How often do they rent it? What do they need? What is the individual price versus the book price? One of the lists that she printed out on October 23rd, just before her meeting with Equipment Share executives, was that list of information that had her clients, the revenue that they generated for the month, the book rate of the equipment, and the rate that she charged, because you have the ability to negotiate with the clients, and there's a floor you can't drop below, but between the book rate and the floor, you have a lot of flexibility to negotiate prices. So that's the kind of thing I'm talking about, Judge Campbell, the specific information on what you're renting, what you need, and the price that you're charging for it. And armed with that information, this is why the law comes in to protect it. Armed with that information, you can leave Thursday and Friday pick right up where you left off.
But Company X could have shared all that information with anyone who called if they wanted to. I mean, you weren't holding your customers to confidentiality about the prices you were charging or the equipment that they were using from you. You weren't requiring them to keep anything confidential.
You're correct, Judge Bailey. There's nothing in the record that says we were requiring that. So Company X can do that.
Okay.
And if Company X does that, that's one of the factual issues. In fact, this court's decision in Emke, which we talk about, where the court said a limited publication for a restricted purpose does not cause the owner of the trade secret to lose protection. It's cited to Metallurgical Industries versus Fortec.
So let's say this, is there any evidence in the record, let's say I'm Equipment Share, I pick up the phone, I call customer A, and I say, I'll beat your price. And they say, okay, here's our prices, here are our needs, beat it. Is there anything, I think that's legal, what's the statute say? Permissible and possibly readily ascertainable if you assume people act in their self-interest. Corporations act in their self-interest. So just, I'll beat your pricing, what do you need? All that stuff. That comes up in the conversation, how is that protected?
You can do all that. You can recreate the information, you can get the information, you can go to the person and say, what price is Ahern or Sunbelt or somebody else charging you? But that's a factual issue. Did she do that? Or did she just take the information that she had, including some of what she printed out?
Yes, I think the factual issue would be it either is or it isn't possible to get that information through a normal course, which is, here's the 100 customers, you call 20, and tell them, we will beat your price. What do you need? And you would have to disprove that's not available. You're not going to find out all of this information through that common sense channel.
I disagree with that, Your Honor. It's not, is it possible? Is it readily ascertainable? And for example, in Emke, right, one of the things that was held to be a trade secret was a customer workbook that had principles and methods for how do you run a successful car renting business. And this court said, those are in the public domain. You can have access to those. It's possible. But you have to go through a lot of effort. And the more effort that you have to go through, the more likely it is to be considered trade secret.
Right. So you are the plaintiff, your burden, you need evidence in the record to show it's not readily ascertainable. So where is, at summary judgment, the evidence showing, going through that permissible standard path, you couldn't have learned the information? That's what I'm saying.
Well, and that's what I was trying to answer before. Perhaps I didn't quite answer it for you, Your Honor, that the evidence in the record is from Cristina Gutierrez herself and her testimony on how you go about getting that information and all the effort it takes and all the pounding the pavement and the work and the pricing and the negotiation. And that's why she didn't want to turn all that over to Ahern, and that's why she wiped her phone clean. So that's
the question of fact.
Yes.
So we could just look at her testimony. What about damages? Is there anything outside the expert witness that would prove up your burden of proof on damages?
Yes.
If that's excluded?
There's
Let me know.
a couple of things on damages, Judge. The revenue that Ahern was making while Cristina Gutierrez was serving these customers compared to after she left. She was the one who was servicing these customers. They weren't doing business with Equipment Share. Then they went, after she went to Equipment Share, start doing business with Equipment Share. And there's testimony that's not, aside from the expert. I mean, you know, we have the...
Okay, so revenue, you said. What else?
Profits, revenue profits.
Profits.
Compensation that Ahern pays to Cristina Gutierrez while she's working and while she's providing information to Equipment Share and working on behalf of Equipment Share.
And then how do we account for COVID?
Well,
We're sandwiching COVID, right?
yeah, if we're not talking about the expert, we account,
No. I said to meet your burden of proving damages as an element of the claim under Arizona law. If the expert opinion is kicked, is there enough evidence there other than that to get you to trial?
Yes.
And what is it?
It's that evidence of the
And
revenue.
who accounts for COVID?
Well, COVID is accounted for because that's the revenue that was produced during COVID. That's the revenue that Cristina Gutierrez was able to generate for Equipment Share, selling the same equipment. And
I thought the revenues were like a 27%, these huge profit years in advance, and then the expert.
Yeah, I'm talking about what's available outside the expert's opinion.
Yeah, exactly. Right.
So I'm talking about you said, how do we account for COVID?
Right.
We have the actual numbers. We know what revenue Cristina Gutierrez was able to generate for Equipment Share. We have the invoices. And we have a chart of the differences in revenue for Ahern while Cristina Gutierrez was there and after. And we have the invoices from Equipment Share to show what she sold to them at Equipment Share, at what price, less than she sold at Ahern.
And there's enough there for a jury, a reasonable jury, to make what's the word? It's an adjective, specific damage amount.
Yes, I think, and I would cite the court to the Supreme Court's opinion in Robertson versus Sixpence Inns, where it says the burden on causation is to have sufficient evidence so a jury could conclude that even if the defendant's conduct contributed only a little to the plaintiff's damages, is there enough for a reasonable jury to say that the damages would not have occurred but for the conduct? And here, when you're dealing with customer A through F at Ahern, you leave, customer A through F revenue plummets at Ahern, and customer A through F, because you were selling them the same products at Equipment Share, goes from zero to whatever it is. That is a reasonable connection right there.
But if Ahern had been concerned about that in the first instance, they would have had her sign a non-compete.
Well, they could have had her sign a non-compete, but they didn't. But Judge Bailey, still, the law provides protection outside of a non-compete if we can meet the trade secret definition, which I think we can. And I think that I really think the court's decisions in Emke and Khaleesi are very helpful, and they're right on. And if you look at, I'll cite you to paragraphs 15, 16, 17, 18 in Khaleesi that talk about the kinds of things that are protected as trade secrets and the efforts that you have to go through. And this is right on. And then even the cases that this court cited in Khaleesi, there's some very good cases there that talk about the same kind of thing. What kind of information can be protected?
Is Ms. Gutierrez's appraisal of her efforts Is that what the court needs to find to say substantial efforts to identify and cultivate its customer base? I mean, you say she had to pound a lot of pavement, but what is the standard by which a court is judging what substantial efforts are as opposed to just, if someone weren't able to get out of their office, it's COVID, and they're trying to get new customers, they can't just do it with the phone in their living room? Yes, it's a lot of phone calls. Is that a substantial effort, or a substantial effort something different? How is a court to judge that? Because that's what the court's being asked in a trade secret case under Khaleesi.
Yeah, and I think you look at the effort that the person themselves described that they had to go through in order to get this kind of information. And this, one of the things that the court looks at also in Khaleesi and others is what's the demonstrable competitive advantage. So if you take this information that you developed for Ahern, you can go right out and use it without having to go through all those steps. And that's why it's not readily ascertainable, because you have to go through all this effort and all these steps. Oh, okay.
All right.
I was going to ask to
Thank
reserve,
you.
but I'm
All
at
right.
zeros. Thank you.
When you're ready.
Good morning, Your Honors.
Good morning.
Excuse me. Judge Campbell, Judge Bailey, Judge Weinswick. I think a lot of my oral argument ground has already been covered, because I think you, Your Honors, have really honed in on what's missing here. There's a very high or very low signal-to-noise ratio in this case. There's a lot of rhetoric about effort put into trade secrets and high-level discussion of case law. What's missing is summary judgment evidence as to whether or not the information complained of is actually trade secret, how it's maintained, how it's gathered, and whether or not it qualifies.
So in Khaleesi, if I could just give you a quote, and I'm sorry, I just have part of the sentence. It said, describing what kind of trade secret you could have protection for, quote, the particular needs, preferences, and characteristics, end quote, of a customer. How isn't this information, or at least the commission revenue report, which had revenue, purchase history, contact information, how is that not, quote, particular needs, preferences, and characteristics of a customer?
Well, first, I don't know that the commission report had contact information. I know that, I think Mr. Prinkevich started to say that, but I think it's simply the name of the customer, the book rate, and the revenue. It's a commission report, and the testimony is that Ms. Gutierrez printed that out because she was going to be talking to somebody about a new job, and she wanted to know where she stood from a commission standpoint. There is no evidence in this record that that commission report ever left Ahern's offices, was ever used, communicated.
Right, but you don't want to wait. Yeah, I suppose you can rest on that argument, but is there any evidence in the record that, you have that quote from her, I found every, bleeping, is that where you want to go to?
Well, the every freaking rate sheet is.
But we're talking facts now. You don't want to be here.
Right, no, you're correct, Your Honor. So many different issues floating in this single question. But that type of information, if it is gathered and it's a compilation that is something that the employer has assembled, and it's a database, it's reduced to some form of list, it's something that she could take with her. But there's no allegation that what Christina knew was Ahern's customer base.
Right. What they're leveraging a trade secret to get a lobotomy.
Exactly. The only information that she's accused of, other than, with the exception of printing out the commission sheets, which there's an explanation for, this June 2019 list that she found when she was doing searches for documents, and the rate sheets, right? It's information that's in her mind. It's the type of stuff that anybody that's going to work in the industry is going to learn, and she's not required to get the prefrontal lobotomy, as the case law says. Typically speaking, when you see that type of information, you're not looking at an individual relationship, like in Khaleesi, what type of information is being protected. You're not looking at a single customer relationship or even a subset of those customers that an individual salesperson would have a relationship with. And that's what this comes down to, is that the information about who the customer is, that's readily ascertainable. I think that that's clear from the record. But the relationship information is really the effort that she's putting in. It's not gaining additional information. It's developing a relationship with these customers. And so when you start looking at the type of information in Khaleesi, what you're really talking about is the institutional knowledge of the employer, and that if that gets misappropriated, a competitor is going to have a field day with it. But there's no evidence that what she took with her, if anything, is anything other than the relationship information, the needs of the customer, the type of stuff that Mascari talks about not being trade secret because you're not required to get a free prefrontal lobotomy, that's in her mind. And that's really where the distinction here is, Your Honor. Ahern is trying to leverage a confidentiality agreement into a non-compete. And you see that clearly when Ahern talks about damages. We haven't talked about Curtis. If Your Honors have any questions about Curtis's opinion, I'm happy to address it. But the question, Your Honor, Judge Weinswig asked at the end about what's your evidence of damages, there may be numbers that they could put on a board, but there is zero evidence connecting those numbers to any wrongdoing by Equipment Share or Christina Gutierrez. They would ask a court and a jury to assume that if there was a customer for which there was revenue, and that revenue went down after Christina departed, that was caused by Equipment Share.
So you're saying they needed the expert for the causation? Because
They
they
do
could
need the
come up
expert.
with a number, but they couldn't, they don't have evidence in the record
That's
that
the missing
directly
link.
correlates to causation without the expert report.
Correct, Your
Okay.
Honor. There is nothing in this record. There are no interviews with customers where they ask, why is it that you went to Equipment Share? The reason that a given customer stopped doing business with Ahern is a mystery on this record. There's no evidence of it. The reason that a given customer started doing business with Christina, there's no evidence of that. Ahern would ask this court and a jury simply to assume that if there's revenue on Equipment Share's side, every penny of it is attributable to wrongdoing. But it's clear that Christina had a right to compete, Christina had a right to solicit. So the only damages that they suffer is to the extent that she actually used any of this information in doing that. Zero evidence of that on this record.
Let me take you back to your colleague's emphasis of Gutierrez's words as indicative of meeting that, was it subsection A?
Mm-hmm.
What's your if I go back there? I mean, I've read it already, but I'll go back and reread it. Does that create a question of fact?
No, Your Honor, because there is no factual question about the effort she says went into creating these relationships. The issue
Well,
is...
she said it was pretty extensive. I mean, whatever the effort was, whether it rises to the level of substantial or not, it obviously from her own mouth was more than just picking up the phone in one phone call and being able to get to the person she needed to get to do her job. So I think that's what he's saying, is if she's saying it's substantial effort, what are we to take from that?
I think the missing link here is substantial effort to do what? Is it a substantial effort to learn who the customer is? No. Is it a substantial effort to gain the information as to who the contact person is? You may have to ask a few times. You may have to go back. But is that really the trade secret that we're dealing with here? The other issue that I think is missing from that equation is the testimony about wiping the phone and the argument about wiping the phone. What's always puzzled me about that argument that Ahern asserts in that context is if it's information that was only in Christina Gutierrez's possession because it was on her phone, and it was information that Ahern didn't have and wasn't aware of, how can that information be Ahern's trade secret? That goes right back to the issue of the relationship and the effort that she put in to learn the industry, learn the customer base, and we're only talking about her subset of customers. We're not talking about the entirety of Ahern's customer base here. And so I think that when you talk about, or she talks about, substantial effort that goes into gaining a customer, I think the proper way to read that is it's substantial effort to work your way in and develop the relationship and gain the customer, not a substantial effort to identify the customer, to identify what they're paying. It's getting
Is
your
that really
foot
what
in
we
the
want a limiting principle to be, though, is that if you're an employee but you hide all of the information that you're using to the advantage of your employer, but you never really share it in a place where the employer can see it, but you're benefiting the employer, that somehow you get out from under trade secret? As long as you keep it on your phone and not on anything that the company owns?
Well, I think, how can it be the company's trade secret? It's not something that the company developed. It's a relationship and information about a relationship that she developed, potentially while employed, and they could easily have imported any of that information in the database. They could have compiled it. They didn't. It's simply information about a relationship that we're dealing with here. And I think under the facts of this case and the facts of this record, that's not enough to establish trade secret protection. As your honors have pointed out, you have to call twice. Is that substantially harder than having to call once? There is no obligation on these customers to maintain this information as secret. Anybody can ask for it. The customers themselves can disclose it. The record is clear on that, particularly when it comes to the rate sheet. And a lot's been said about this every freaking rate sheet text message, and whether or not Judge Thomason basically took an inference from that was adverse to the plaintiff. I think if you read that ruling, what Judge Thomason said was, well, there are multiple interpretations of that, but at the end of the day, I've already determined that rate sheets are not confidential, so it really doesn't matter. That's not an instance where there was an inference that was taken against the plaintiff. With regard to the summary judgment record, let me talk about the rate sheets and talk about the evidence that was presented about the customer pricing and whether or not it's confidential. One of the things I think it's important to remember is that in EquipmentShare's moving papers, we supported the idea that there's price matching within the industry. If you have price matching, how can information be confidential as far as pricing? And that ordinarily customers will shop around. That was supported by a declaration from Jason O'Connor, who is a customer in the industry. Now, Ahern objects to that because he has no experience in the rental industry. But I think the point is that declaration contains factual statements that are uncontroverted, that rate sheets are shared, pricing information is shared, there's price matching. Kaufman's deposition, which is also in the record, he is a former Ahern sales rep, contemporary of Ms. Gutierrez, and he testified about price matching. When it came time to controvert that evidence and the statement in the statement of facts that this information is generally known, the customers are generally known, the only thing that was presented were two excerpts from, one was from Ryan Hudson, the other was from Larry Burford. And both of those statements merely contain the statement, both of those segments of testimony merely contain the statement that I consider this information confidential. Well, that's not a factual controverting statement. That's simply a lay opinion that something's confidential. If that is sufficient to controvert...
Who said that?
It was Ryan Hudson and Larry Burford were the two. And it's, if you look at, and I apologize, it's index of record 101 through 115 is their entirety of their statement of facts, and I wasn't able to get it broken down how the Court of Appeals has that broken out. But Hudson is Exhibit D, to their statement of facts. Burford is identified as E, but it's actually F. And it's simply a conclusory statement that they make. If that's sufficient to create an issue of fact, then you're never going to have summary judgment in one of these cases, because I could take out a billboard with my trade secret information and then submit a declaration that says I think this is confidential, and now there's an issue of fact. That's simply a conclusory statement that does nothing to controvert on the record what we've presented with regard to the ready availability of customer identities information and pricing information. So with that, I've got about 5 minutes left. I want to reserve that time for Mr. Griffin, who represents Ms. Gutierrez. Are there any questions for me before I turn the floor over?
I mean, it's not clear to me what's appealing, from like, are you equipment shares?
I'm equipment share, yes.
Okay, and so you're both on the brief? The
We have
answering
separate
brief?
briefs,
You have separate answering briefs?
correct.
Okay.
Because we were out after the first motion for summary judgment and after the...
But you filed in our court an answering brief?
Correct. And then Mr. Griffin represents Ms. Gutierrez.
Who can talk about sanctions? Like, as far as the fee award at the
Oh.
end, so the 349 instead of 340-101?
That would be me, Your Honor.
Okay.
Because that award was...
Why do you, first of all, is that needed because there's no contract, is what we're saying, between equipment share, that the only way you're going to get fees is under 349?
Correct.
And what is so crazy here and meritless that you would sanction under 349?
I think if Your Honor looks at the summary judgment record that I've just laid out, you'll see that the core of the case was wholly unsupported other than with conclusory arguments. I think the other thing that the court has to bear in mind is the conduct of conduct of Ahern across the litigation. This is one of 30 cases that Ahern filed against equipment share, in every instance in an individual employee, and resisted every attempt to consolidate, streamline, anything else. I think that the record is clear that this was a tenuous case at best, based upon the lack of evidence put forth.
Well, that's not the standard for 349.
Well, it's objectively groundless, yes.
Well, tenuous is more of a hedge, but yeah, okay.
Right. But if you look at the conduct that's at issue here for Ahern,
You're saying to look at the other 20 cases,
look at
color the back.
Yeah, look at the fact that when they decided they wanted to file another case against Bonner, instead of adding Bonner to this case, they file a case against Bonner without naming equipment share, so it can't be removed, and then they amend as soon as Bonner is served, and then resist consolidation and refuse to coordinate. This is a master plan to avoid.
I don't want to take your time,
Yes.
so.
Thank you, Your Honor.
Thank you and good morning. I'm Thomas Griffin. I represent Christina Gutierrez. I'm here to address solely the issue of the court's denial of default judgment. And there are three main issues on that. One is the standard, which is abuse of discretion. The second is the timing and the fact that the relevant text messages were deleted prior to the commencement of the lawsuit and prior to the obligation to preserve began. And the third is the impact, and that the Superior Court judge says that it was both highly unlikely and incomprehensible that any of the missing text messages would have made a difference in his ruling. On the standard of abuse of discretion, even if you disagree with the opinion of the Superior Court, even if you would have ruled differently, you have to affirm unless the Superior Court exceeded its bounds of reasons and committed a clear error of judgment. And here, you have to find that twice. First, when it said there was no intent to deceive, and second, when it said that it's not in the interest of justice to enter a default judgment. On the timing, Ahern repeatedly references these hundreds of text messages. They're text messages between Ms. Gutierrez, Mr. Bonner, who Ahern sued, Mr. Martinez, who Ahern sued, and a variety of customers of Ahern and or equipment share. In the order denying default judgment, the court addresses those and says that the bulk of the texts are these texts which were from September of 2019 to December of 2019.
Don't you want to emphasize that there was an evidentiary hearing on the issue?
Yes. Yes.
And what does that mean to us?
So the judge ultimately, with the knowledge of everything that happened in this case, everything that happened in the Bonner case, which he also presided over, the knowledge that there was the Martinez case, and everything that was presented in the evidentiary hearing when Ahern got to cross-examine on Ms. Martinez on when the texts were deleted, why the texts were deleted.
Credibility.
The judge listened to all of that and determined, one, they were the relevant text messages, which went to liability, not even damages, were deleted prior to the commencement of the lawsuit. And then he set forth a litany of reasons why it wasn't in the interest of justice to enter default judgment. There was no merit. They didn't prove their damages. Again, he said it's highly unlikely and incomprehensible that they would have made a difference. He said there would have to be, his word was conspiracy for these three individuals and all of the customers to eliminate all information. He said his words were that Ahern engaged in very thorough and very aggressive and thorough litigation against not only Ms. Gutierrez, but many others, and no incriminating evidence ever came up. Some of these texts came up in this case and other cases, and none of them were incriminating.
And she was sanctioned 20 grand.
She was sanctioned lesser than default judgment.
Okay.
Thank you.
Thank you for your argument. We will render a decision in due course, and at this time, we stand adjourned.